Hello and welcome to the 49th episode of Business Litigation TV. I'm your host, Jesse David Eisenberg. I'm a New York business litigation attorney, and this is the internet's most passionate show about business litigation. Now, as a business litigation attorney, I mostly deal with problems once a contract has been breached. But before the contract gets breached, there's always a contract dispute. Now, a contract dispute gets contentious normally, then someone breaches it, and a lawyer gets called, and now you're in litigation. However, there are some options to try and avoid litigation in a contract dispute, even before a lawsuit is filed or a contract has, like I said, already been breached. So, I'm going to talk about some of the main methods. The first one is negotiation. Basically, the two sides come together and negotiate, say, I'll give you this for this, and you come to some kind of agreement. Sometimes you have an attorney there representing each side in the negotiation to try and make it smoother and to work out the details a lot easier. Then you can do what's called mediation. Now, mediation is non-binding, which means a mediator can try and get the two sides to come to a solution, but they can't dictate the solution, and you don't have to listen to it. So what usually happens, again, normally you are represented by an attorney. You guys come before the mediator, you both plead your case to the mediator, and then the mediator has both sides separate, and the mediator goes back and forth to each side going, well, can we get the deal done if we do this? What if we do this? And they try and broker some kind of agreement. The third option, before you have to go to litigation, is something called arbitration. Now, when you agree to go to an arbiter, you agree that their decision will be final. Now, you can appeal it, you can bring it to court again, but you're saying it's basically like mediation again. You have an attorney, usually, you plead your case to the arbiter, and the arbiter makes a decision. But where it's different than mediation, that decision is now a final decision. So the arbiter will say, I listened to both sides, I'm going with X or I'm going with Y, and this is why. Or sometimes the arbiter just finds something right in the middle, that he thinks or she thinks would work best. Now, the goal of negotiation, mediation, and arbitration, though, is to try and broker some kind of agreement or come to some kind of resolution without having to be dragged all the way through the long and lengthy litigation process. Remember, too, when you're doing litigation, the most important thing is, especially if you're a business person, you may be doing business with them in the future. So you have to really think, do you want to go through litigation or do you want to try and find a solution? Because at the end of the day, hopefully you guys can get along and make lots of money together. And that's what really counts. Doing what's best for the business and everybody winning. So I hope this helps understand what you can do in a contract dispute. You have any questions, feel free to email me, jesse@jdelaw.nyc. And as always, thanks for watching.